Please be brief.
Oh, I will. My name is Shakira Sanders. I am a professor of constitutional law at the University of Idaho College of Law here in Boise. My courses and scholarly publications focus on government structure and individual rights and liberties under the United States Constitution. But I am here in my personal capacity today. As the lone dissenter in Plessy versus Ferguson, Justice John Marshall Harlan stated that our Constitution is colorblind and neither knows nor tolerates classes among citizens. The question before this body today is whether Justice Harlan's theory of a constitution that is colorblind also applies to sexual orientation and gender identity. This question was partially answered in 3 recent cases decided by the United States Supreme Court, the first being Romer versus Evans, where the court reasoned that if equal protection means anything, it means that the law it means that the bare desire to harm a politically unpopular group cannot constitute a legitimate government interest. Several years later, in Lawrence versus Texas, the United States Supreme Court overturned a Texas statute criminalizing sodomy and held that one's private sexual conduct between consulting individuals cannot be criminalized solely upon the grounds of immorality. And finally, in United States versus Windsor, the court emphasized that laws that fail to protect sexual minorities materially harm and demean those individuals. One of the resonating things here is the concern of religious belief. I want to remind this body that the First Amendment talks about free exercise and the Establishment Clause. The Establishment Clause establishes an absolute right to belief, but there is no absolute right to act. There are all types of qualifications on our right of free exercise, and anti-discrimination ordinances would fit into existing prior law. I support HB 2, and I think this is a fine day for democracy in the state of Idaho.
Are there questions?
Thank you.
Thank you.